Ladies and gentlemen, welcome back to the Indie Zone. Judge Stephen J. Hippler has filed an order on state's motion in limine regarding family members in the courtroom. First, this order addresses immediate family members of the victims to be present during the entire trial, regardless of whether they are scheduled to testify or not. And attached to the state's motion, Exhibit S's and Sam 1 is a list of those individuals the state considers to be immediate families. The defendant stipulates that the individuals listed in Exhibit S1 may remain in the courtroom during the trial. The caveat being, the defendant asks that the court provide guidance as to the proper courtroom decorum to discourage family members from wearing clothing or apparel that could be viewed to be coercive to Mr. Kohberger. At the appropriate time, Judge Hippler states the court will exercise its discretion. So he's not making a ruling right now on appropriate clothing in the courtroom. He does have a footnote here. Nevertheless, the parties can rest assured that those attending trial will not be permitted to display in any form or media messages or signs of support or opposition related to the parties or issues in this case. Further, no demonstrations or outbursts of any kind will be permitted or tolerated. Then he states, however, in his response to the state's motion, defendant requests that his immediate family members, his siblings and parents, be allowed in the courtroom, arguing their exclusion would violate his Sixth Amendment right to a fair trial. The state objects on the grounds that while family members of victims have a constitutional and statutory right to attend trial, there is no comparable provision for a defendant's family member. The state also contends that it intends to call members of the defendant's family as witnesses at trial and will ask the court to exclude any testifying witnesses from the courtroom. Then the court goes into the United States Supreme Court has recognized that the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant at the very least to have his friends, relatives, and counsel present, no matter with what offense he may be charged. Courts recognize that having a defendant's family members present at trial advances the value served by the right to public trial, i.e., ensuring fair proceedings, reminding the prosecutor and judge of their grave responsibilities and discouraging perjury and encouraging witnesses to come forward. However, like other constitutional rights, a defendant's right to a public trial is not absolute. A partial closure of a trial, one that excludes a limited number of persons for either the entire or part of the trial, is permitted if there is an overriding interest for the closure, and the closure is narrowly tailored to serve that interest. Here, the purpose for the closure requested by the state is IRE 615, which provides in relevant part that at a party's request, the court may order witnesses excluded so that they cannot hear the other witness's testimony. The judge then continues, while the court is sensitive to the state's concerns about allowing testifying witnesses present during trial, the court is also sensitive to the fact that it is anticipated to be a lengthy trial and the defendant would like the support of his family. The scope of his family members' testimony is likely going to be limited, according to Judge Hippler, but in an effort to reach a solution that upholds the rights of both parties, the court will request the state to submit for an ex parte in-camera review a list it intends to call at trial and purpose for calling each one of them. The state must also identify why each family member cannot be called very early in its case in chief and articulate why exclusion of the family member is necessary. Particularly given the unprecedented publicity of this case, the state must submit these materials no later than April 25th. The court will provide the parties with its decision on or before the pretrial conference at May 15th. For now, the motion is granted as to the homicide victim's family and reserved to the defendant's family members. In the event that the state does proceed and include these witnesses on their to be filed witness list, all eyes will then be on the Pennsylvania court docket, Monroe County, to see if a case is filed there to domesticate any Idaho witness subpoena for the Kohberger family members. Thank you for joining us.